Good evening. I will be reporting on nominal damages. This type of damage is provided for in Articles 2221, 2222, and 2223 of the new Civil Code. Article 2222 uh, says that nominal damages may be awarded in every obligation arising from any source enumerated in Article 1157 of the new Civil Code, or where any property right has been invaded. So what are the obligations enumerated in 1157? These are the obligations that arise from laws, contracts, acts or omissions punishable by law, quasi-delicts, and quasi-contracts. Article 2221 defines nominal damages as those awarded by the courts in order that the plaintiff's right, which has been violated, may be vindicated or recognized, and not for the purpose of indemnifying the plaintiff's loss. So what are the key points? There is a right violated, and it has to be recognized. The recognition is not for the purpose of indemnification or compensation. Okay? In order to extract the nature and purpose of nominal damage, we will probe further into the provision of Article 2221. It says in here, violation of a right. An award for nominal damage is in order when a right is violated. In the case of People versus Marquez, where Marquez was accused by Merano of kidnapping her 3 months old baby, the Supreme Court affirmed the Court of Appeals award of 20,000 pesos as nominal damage for Merano's right as a parent, which was violated and invaded and must be vindicated and recognized, thereby justifying the award of nominal damage. Second, an award for nominal damage is in order when there is no actual damage caused or where there was no loss proven. As a general rule, nominal damages are awarded in one of two occasions. One is when a plaintiff is seeking compensation but has failed to present evidence of his loss. Another is when a plaintiff has not suffered the physical losses but has been victimized in some way, and so nominal damages are awarded when the plaintiff has not uh, when the plaintiff is legally in the right but has not suffered substantial losses. Because the plaintiff has no established need for compensation, the amount awarded in these cases are usually small and may only cover the plaintiff's legal costs. And third is nominal damages are awarded in consideration of equity. In the case of Guanyo versus Makati Shangri-La, where the spouses Guanyo entered into a contract with Makati Shangri-La, where the latter agreed to host the former's wedding reception. The spouses Guanyo instituted a complaint against the hotel for breach of contract, claiming that the staff were rude and there were delays in the services during the reception. The hotel countered that it was the increase in the number of visitors from the originally agreed number that caused the inconveniences. So the lower court ordered actual, moral, and exemplary damages plus attorney's fees. But the Court of Appeals disagreed. When the case reached the Supreme Court held that under the consideration of equity, it is deemed just to award the amount of 50,000 pesos by way of nominal damages to the petitioners. This is for the discomfiture that they were subjected to during the event. The court recognizes that every person is entitled to respect of his dignity, personality, privacy, and peace of mind. The respondent's lack of prudence is an affront to the right of the petitioners. So, what is the nature and how are nominal damages arrived at or determined? It is generally held that a nominal damage is a substantial claim based upon the violation of a legal right, and for some authors, they claim that nominal damages are damages in name only and not in fact. These are allowed not as an equivalent of a wrong inflicted, but simply a recognition of the existence of a technical injury. Second, it must commensurate to the injury suffered, not just based on highly speculative claims. When actual or compensatory damages are not proven, as in the case of Gonzalez versus People, where Gonzalez was accused of arson and he was convicted by the trial and the appellate courts. The Supreme Court also affirmed the conviction but made a modification on the award for damages. The Supreme Court said the records do not show any concrete proof of the amount of actual damage suffered by each of the complaining witnesses. Thus, it cannot grant actual damages, but it may, however, award nominal damages. Also, in another case decided by the Supreme Court, they said that because petitioners sustained injury but which were not adequately and properly proved, and that because the case has dragged on for a long period of time, it was found reasonable to grant in petitioner's favor nominal damages in recognition of the existence of a technical injury. The amount to be awarded as damages should at least commensurate to the injury that is sustained by the petitioner, considering the concept and purpose of said damages. Another is for some special reason extant to the case. This simply means that the particular circumstances of a case will help in determining the amount of damages to be awarded. The assessment of damage is left to the discretion of the court according to the circumstances of the case. Allegations in the complaints can be a basis for determination of a fair amount of nominal damages, fair and just depending on the circumstances. Okay. Lastly, what is the effect of nominal damage when awarded? This is embodied in Article 2223, where it says, an award for nominal damage precludes further contests upon the right involved and all accessory questions as between the parties to the suit or the respective heirs and assigns. In other words, once nominal damage is awarded, it settles the obligation. So, heirs or successors can no longer contest it in the future. Nominal damages cannot coexist with actual or compensatory damages. Why? Because actual damages are based on actual losses and compensatory damages are purposely to compensate for the losses, whereas nominal damages are mere recognition of a right that is violated. It is neither compensatory nor um, actual. And so I say thank you very much, and that ends my report. Good night.